Thank you so much, Josephina. Thank you so much, Justin. To all of our participants, again, just a very quick disclaimer. The meeting will be recorded. We hope to have your consent so that we can always have this meeting again and so that we can share it with some of our colleagues and members who have not been able to join us today. Yes, so thank you so much for joining. Good afternoon, good morning from wherever you are coming from. My name is Rachel Magege. I am a very proud member of the Tanzania Privacy Professionals Association. I am a lawyer by profession. My areas of strength are in data protection and privacy. I am based here in Dar es Salaam, Tanzania. And we have several other members of the Tanzania Privacy Professionals Association here with us. We will be able to interact with them over the chat and over the conversation as well. And we're happy to have you in this webinar. Thank you so much for joining us. Thank you for making time. Today's topic is very sensitive. Today's topic is very interesting. We are going to be discussing about data protection in judicial proceedings. We're going to talk about different kinds of matters and proceedings in courts and how the parties can be protected, whether in human or in their personal information. And so, as you may have seen in the announcements and in the posters, we have our wonderful panelists, our wonderful speakers. One of them, unfortunately, just had an emergency at the very last minute, Mariam Kisimbe, and so she's not able to join us today. She sends you her apologies, but we do hope to have her next time. Yes, and so just a little bit of a background to this webinar. We have been having a lot of conversations amongst ourselves as the Tanzania Privacy Professionals Association. We follow up with what is happening with the new Data Protection Act and the very new Data Protection Commission. And so it came to our attention that in as much as people's personal information should be protected, whether in companies, in business, in trade. We also saw it important to look at judicial proceedings, where we see that sometimes some of these proceedings may be public, even media entities may be present, and some of them may be private. But even for these matters that may be public, we still see that a lot of personal information is thrown out there, and in one way or another, this might harm the individuals. Specifically for Tanzania, we will share a link here with you so you can read more on this case, but this was a matrimonial case of 2023 between the parties, because it's public. The parties were Salome Lorian Mganga versus Michael Peter Motau. And this was a matrimonial matter seeking annulment of the marriage. And so their three names can be seen in the judgments, what happened in their lives, what was the matter, and everything is out there in this judgment. So thinking about that made us realize that perhaps there is need to have a conversation about protecting people's personal information, even in courts. So this is one example. This is the matrimonial matter, but there are probably a number of cases involving minors, for example, defilement cases where they put the actual name of the minor and of the abuser as well. So how much protection is being afforded to these parties in judicial proceedings? So think about all the different cases that you have read about, that you have seen. And I know personally, I've seen a number of matrimonial cases from people that I know personally in my life. So that really does make you think, and it really can sometimes also make you feel a little bit uncomfortable when you do see this person in real life, let's be honest, because you've read something that is very sensitive about them from courts. You've seen what happens to them. So we are going to have an open conversation today. We're going to be very honest, and I hope that we will be able to learn so much from each other. Yes? Thank you so much. That was just a little bit of a background. And so the Tanzania Privacy Professionals Association usually holds different webinars from time to time on these conversations for education, for learning also, and for seeing how we can better walk in this walk on data protection and privacy. So we welcome you here today. And We will use at least an hour, a little bit more than that. Also, we will make sure that after our panelists have given their presentations and we have had this conversation, we will leave room for questions and answers. Feel free to use the chat room to ask any questions. Feel free to introduce yourself. We'd like to know where you're from, what areas of work you do, and whether you've come across any of these cases in court that have put out very sensitive information. So thank you very much for listening to me. I would like to draw your attention to our panelists today. And yes, the case in reference has been shared in the chat. Please do have a read. I would like to welcome our panelists to introduce themselves, just very briefly, starting with Ms. Vanessa A. Please tell us where you're coming from and what work you do. And then after that, we will have Mr. Mutalemwa Kishenyi also introduce himself, and then we will get right into the conversation. Welcome, Ms. Vanessa.
Hi, everyone. Good afternoon. Can you hear me?
Yes. Good afternoon.
Good afternoon. Hi. So my name is Vanessa Obi. I'm a data privacy lawyer at Bawa Nigodalu in Nigeria. We've worked on several matters dealing with data protection as far as it pertains to Nigerian laws. We recently got our Nigeria data protection law passed into an act last year, 2023. So this is our primary legislation here. But yes, I'm very excited to speak with everyone here and discuss this very interesting topic. Thank you for having me.
Thank you so much. Thank you so much, Vanessa. We're happy to have you as well. And congratulations to Nigeria for having this new Data Protection Act. And also congratulations on the very recent conference under the Nigeria Bar Association. And it was really wonderful. Mr. Mutalemwa, you're welcome.
Thank you so much. My name is Mutalemwa Kishenyi. I'm a senior state attorney working with the Personal Data Protection Commission. But I've also done prosecution extensively, so I can understand the consequences of the topic at hand. Thank you.
Thank you very, very much, Mr. Mutalemwa. And the first question actually goes to you. To all the people in our audience, some might not be from Tanzania. Could you please share a little bit with everyone about the new Data Protection Act of Tanzania, and specifically what personal information does the law seek to protect? Just in a general summary, and we'd love to hear that from you. Thank you.
Thank you, Magege. So our law lists items that are categorized as personal data. So it goes by saying personal data means data about an identifiable person recorded in any form, and it includes personal data related to race, national, ethnic origin, religion, age, marital status of an individual, data relating to education, medical, criminal or employment history, any identifying number, symbol, or particular or other particular assigned to an individual, address, fingerprint, blood type, names of individuals, and such other related information. Our law lists them as personal data. Then as to sensitive personal data, this is a category of information that must be treated with an extra security, and they include genetic data, data related to children, data related to offenses, financial transactions of an individual, security measures or biometric data, and they also include data relating to race, ethnic origin, political opinion, religious philosophy, religious or philosophical beliefs, affiliation, trade union membership, gender, and data concerning health or sex life. The list is long, but at least you can see the types of sensitive data that is listed in the section, defining section, our section 3 of the PDPA sets out the specific categories of personal data that has to be treated with extra care.
Thank you so much, Mr. Mutalemwa. Very comprehensive, and the list is long. And as we continue this conversation, we will be sharing also a link to the Personal Data Protection Act of Tanzania to anyone who may be interested, so that they can follow along with these sections. Thank you very much. I've heard you mention DNA, religion, children, data related to children, so many different things. And one thing that does come up with these court cases is just by looking at someone's name, sometimes people are able to deduce what religion this person is, and even reading the judgments, people are able to tell if this is a child, if this is a husband or a wife. And so thank you so much for specifying all of those different data that is protected under the Personal Data Protection Act of Tanzania. And we will come to you again, Mr. Mutalemwa. I'm jumping now to Ms. Vanessa, where we would like to hear from you about the general principles and legal requirements when it comes to publicizing court decisions. So number one, when it comes to publicizing court decisions, but also when it comes to the proceedings themselves, when the proceedings are happening, what are the procedures? Are there some cases that should only be public? Are there others that should be private? And how do they come to that decision that this matter, this judicial proceeding should be very private and this one can be open to the public? Thank you. Welcome.
Okay. Hi, everyone. Okay. So in Nigeria, generally, with judicial proceedings, they're generally public, right? Before you institute any proceedings here, you have to name the parties as well. There are only very few that I'm guessing would be excluded from public records, something like changing your name, or, there's a the list is very, very exclusive. But with respect to this Salome kind of case, right? The Nigerian Data Protection Act does not really exclude, it excludes judicial proceedings from like the scope of application. So at several points, it just keeps saying that the exclusion to whatever principle they've set out in the act is processing necessary for the establishment, exercise, or defense of a legal claim, or obtaining legal advice, or the conduct of legal proceedings. As a result of this, the Salome case would have pretty much been replicated here in Nigeria, where the details of this kind of proceeding, even though it has to do with the sexual life of two persons, it would also have to be public as a result. And this obviously is the crux of this entire webinar, because such kind of information typically leads to some level of discrimination when other people, read about it or learn more about it, and then they can identify these persons. He's definitely not going to have the same life he had before with the amount. I mean, we're having a whole webinar about this, and this man's name is clearly, it's clearly evident. So we can do searches, we can ask friends of ours to see if they know this person. And honestly, he can be easily identified because you have the whole name. In a case like this, you'd expect that hopefully they would have redacted or sealed some of these records or something like that. Or maybe the names they would have used just the initials of the individuals. But that's clearly not how it works in most places. But yes, I hope this answers your question.
Yes, it really does. And can you just tell us a little bit more about what kind of cases, for example? So this was a matrimonial case seeking annulment. What other cases, for example, in the context of Nigeria, do they publicize the names of the parties? What are the different cases? Maybe civil, children's cases, criminal cases, government, maybe cases where a government actor is being put in case?
So if it's an administrative case, most times it's just for public records. With individuals, to have some level of privacy here, most people just opt to do alternative dispute resolution with like arbitration or mediation, something that doesn't allow these records to go to public, which is why ADR in Nigeria is a very important part of our legal practice. With like divorce proceedings, even it's still public to a very good extent, and it's not preferable, especially with the fact that children are involved in these things, and as an adult, it's a bit easier to just accept the consequences of you choosing to put your business in front of the court and everything. But with children, they can't exactly consent to this, and it's just an issue generally across our jurisdiction here in Africa, it seems. But I mean, it seems like in the EU, the CJEU has found different ways to kind of expand the category of what's it called, sensitive personal data. In Nigeria, under Data Protection Act here, they say that the NDPC, the commission, could in certain instances expand what kind of sensitive personal data could be included in the category. So sensitive personal data right now, sorry, I have a cold, so my apologies. So sensitive personal data, thank you. Sensitive personal data right now is just genetic and biometric data, race or ethnic origin, religious or similar beliefs, health status, sex life, stuff like that. But in CJEU, a case 184/20, right? The CJEU found that the processing of personal data that is liable to indirectly reveal sensitive information about a natural person, in this kind of case, you can extend or you can widen the scope of sensitive personal data just to afford the kind of protections afforded to sensitive personal data to this other category. So with matrimonial proceedings, even though this is not something that our act allows for, we'd hope that since our own act here says that the NDPC can widen the scope of our sensitive personal data, we hope that in light of this is a good way to argue for this widening of the category. Thank you.
Ms. Vanessa, thank you so much. And I wish you a quick recovery. Thank you so much. We'll try to make sure you don't talk too much in this meeting, but thank you very much. Lovely to hear about what Nigeria is doing. And that also brings us to Tanzania now, and Mr. Mutalemwa, in the Tanzanian context, yes, given that these court decisions, so now we're looking at the judgments in the court decisions, especially in matrimonial matters, often reveal very, very sensitive information. What could be the potential privacy implications for the involved parties? What area of their privacy has been violated? What part of their privacy has not been protected when these judgments and rulings are put out there for everyone?
I think the potential privacy implications on the parties involved in the matrimonial proceedings could range from stigma from your colleagues, from your family members, could range to parties not feeling free to argue their case before the courts, and that could help them prove their case, so to speak. since they are sensitive and they are not assured of the privacy protection, then parties could not feel free to disclose some of the sensitive information, fearing harm. But again, there could be physical or mental harm. Of course, mental harm definitely, but they could also face physical harm.
Yes, Mr. Mutalemwa, this is very, very true. Their safety could be jeopardized, their reputation damaged. It's very easy to judge someone just based on what is written in their judgment and completely dismiss the person. So I do agree with you on that context. And if I may ask you also further to that, so what are some best practices, some rather good options, perhaps that the courts can think about or do, or maybe even they've started thinking about, if possible, on protecting the personal information of parties, especially in matrimonial proceedings, which can be very sensitive, but maybe in some other criminal matters, maybe involving rape, sexual assault. What are some steps or alternatives that the court processes can think about to protect the privacy of these people? Mr. Mutalemwa, it appears you are frozen. Please let me know if you can hear me. Justin and Josephina, am I audible?
Yes. Yes, you are.
Okay. Okay, thank you. Mr. Mutalemwa, can you hear me?
Okay.
I
Maybe
think he's
he
having
can keep,
connection issues.
yeah. So maybe he can keep his camera off, I guess. That might help
Okay.
the situation.
Okay.
Should I take the question in the meantime?
Yes, Vanessa, welcome. And we can come to Mr. Mutalemwa. Yes, tell us about Nigeria. What are some best practices that they can use?
So the Act kind of mentions for some kind of different measures that can be used to ensure the security of personal data generally, right? But when it's sensitive personal data, we hope that these measures, they apply a higher standard, right? So generally, you'd say stuff like pseudonymization or general de-identification of the people. You can de-identify someone by using their initials. So instead of putting their full names, like my name is Vanessa Adana Obi, instead of using my full name, you can use VAO, right? It's still me, but now there's a wider net of people that could possibly have the same initials. And it doesn't directly identify me, even though this is also, legally speaking, these are my initials under the law, right? So it's not like for the public proceedings, I've put on a whole different persona. They've hidden every single aspect of my identity, but we've chosen to just use the initials. You could pseudonymize. It depends on the, what's it called? The technological advancement of the courts or the judiciary, right? If we have like PDF records or like digital records, you can pseudonymize, you can encrypt this data so that only people that have access to this, or you can find a way to redact certain data about this, certain parts of the records, right? So if you're redacting it, you're kind of blackening out some areas, or you're just blacking out the names. And then that way, people can still get the gist of the records for whatever reasons, whether it's research, for judicial precedents, all of that. And that way, everyone still gets the benefit of having the records still relatively public, right? So pretty much these are the kind of things, or asking parties to fill out some confidential records forms or something. So that way, if they opt for this, they have the option of this possible. But yeah, that's what I would suggest.
Thank you, Vanessa. Thank you so much. Kenya does that actually, where the names of the parties are put in initials. And this was something that I found very interesting from the time when I was doing my studies in there, and you could never tell who the parties were. And sometimes you couldn't tell between petitioner and respondents, you couldn't tell who was the man or who was the woman, who was the one who initiated the petition. So it was a very interesting thing to learn about, and definitely works. Mr. Mutalemwa, would like to hear from you too as well. What are some best practices in Tanzania to protect the privacy of parties?
So first and foremost, I second to what the previous speaker contributed. If I should add, some of the best practices that courts could put in place so as to safeguard privacy of parties in proceedings. One of the measures could be confining hearing to confidential schedules, so that you keep out those who are not who are not concerned with the proceedings. Again, courts could come with imposing reporting restrictions to media houses and such other reporters, not to report the proceedings due to their sensitivity. Again, courts could come up with measures to prevent copies of judgments and proceedings or orders from being accessed by the third parties. Such measures could, if that was done in this case, in the judgment we have, then it could not be publicized. It could not be reported in the media or in the law reports, so it does not circulate, so to speak. So such measures could help bring some privacy sensitivity. That's my take.
Yes, Mr. Mutalemwa, thank you. You are very audible and very clear. I was writing down all this important information. Thank you very much. I would like to remind all of our audience members that you are allowed to ask questions throughout this conversation. Please type them in the chat room. But also, as we come to the end of this conversation, just between the panelists, we will be opening up the floor for other comments, feedback, and questions. So please keep them ready, keep them close, and just be as honest as possible with this topic, because it is a very sensitive topic. Yes, and so as we come to wrap up at least the conversation flow with the panelists, I would like to ask this question to both Mr. Mutalemwa and Vanessa. On the matters of arbitration mediation. Vanessa, I know you mentioned how arbitration is a very big thing in Nigeria. There's been a very new arbitration and mediation act. Congratulations to the government of Nigeria on that. But given the popularity that arbitration and mediation are getting these days, do these forums actually offer a better platform for protecting the privacy of the parties? And I say this because, I ask this because, yes, arbitration, mediation are more private, but do they also protect the parties from the mediators and the arbitrators who perhaps may be influenced in one way or another based on the personal and the sensitive information that they do receive from these parties, whether it's marriage certificates, licenses, reports, passports, police complaint forms? Do these measures also protect the privacy of the parties? Ms. Vanessa, and then we'll hear from Mr. Mutalemwa. And how realistic is this in Nigeria and Tanzania?
Right. So like you said, as far as you're using an arbitrator, you're using a human being, right? And if you're using human beings, to some extent, especially with the amount of disclosure that is required for them to deal with these cases, a lot of this information has to be put in front of the mediators or arbitrators, right? And if they have access to this information, I mean, they're legally bound to confidentiality. They cannot, you know, do as they please with this data that you've given to them or you've provided to them. However, I mean, it's also in best interest to also make sure that there's no conflict. These people are not related to any of the parties in any way at all, right? And I know it's still uncomfortable, but at the end of the day, they have to know, right? And it's only so much, there's only so far we can go with like expecting some level of the highest level of privacy when other human beings are involved. But generally, when you want to weigh it, right, you always just have to put it against is this private ADR method, is it going to give me more privacy than going to court? And the answer is always yes, right? It might not give you the utmost level of privacy. If it was going to, it wouldn't involve any other person, right? It would just be between the two parties, unfortunately. The only other person that you could think that is not a person, artificial persons like AI and stuff, those are the only people that it doesn't really matter to them because they're not, But even with AI, we're seeing privacy concerns each and every day, right? So, I mean, if we're having privacy concerns with tech, at least human beings, you can go for them. You can kind of institute something to say that your lawyer went against or your arbitrator went against his confidentiality expectations, right? But I mean, like I said, it's still way better than courts in that way. Yeah, that's the only other that's the only comments I can give on that. Thank you.
Thank you, Ms. Vanessa. At the end of the day, it's still better than courts. Yes, in one way or another.
Yeah. At the end of the day, you just have to weigh
it.
Yeah.
Yes, thank you very much. Mr. Mutalemwa, you are ready to give us your contribution. Welcome.
Could you please remind me the question, please, if you don't mind?
Yes, not a problem. The question was addressing whether arbitration and mediation, as we know, do have components of privacy. And so do they still, in as much as they're private, but do they still offer a better platform of protecting the privacy of these parties, of course, as opposed to courts? So sometimes you will find, for example, in arbitration or mediation, you may have one mediator between the two parties, or you will find in some cases, maybe each party will be present and then they'll have their lawyers present and then a mediator. There may be a personal secretary typing the matter that's going on, or an intern or anybody. So do they still offer that same level of privacy and also protecting the parties from the biases of the mediator or arbitrator as well?
They do bring some sense of privacy, since proceedings and be it mediation or arbitration are always confidential. But we should be mindful of the fact that when mediation fails, then parties will have to resort to courts. So you can see there now. Well, you have opted for mediation, but again, it's not necessarily that mediation should succeed. It could end up in not the matter might not end up with mediation. Hence, parties could find themselves at the doors of the courts of justice. Again, I'm glad that our civil procedure has it compulsory that all cases have to go through ADR. So that is a comfort zone that our law makes it mandatory for parties to go through mediation. So if I should submit, my point is that yes, ADR is the best option because the public is not involved. There is confidentiality, and hence privacy is uplifted.
Very well understood, Mr. Mutalemwa. Thank you very much. Thank you to Ms. Vanessa. I'd like to hear from members of the audience also if they do have any questions at this moment. I know I will be bringing in a last concluding question to our panelists. But in the meantime, I'd also like to hear even from members of the Tanzania Privacy Professionals Association, any more comments and feedback that you may have to this matter, because I know it was a long conversation we had the other day. So Josephina, please help me. Oh yes, Josephina has a comment. You're welcome, Josephina.
Hello, thank you. I could put on my camera, though I am not well made up, so it doesn't matter. So there we go. I hope you can see me. I don't know where I am.
Yes, Josephina, we can see you.
All right,
yes, there.
It doesn't matter. First of all, thanks to the panelists. Thank you for taking your time to do this. I am the person behind the webinar, so I thought it would be appropriate if I just jump in and contribute on the topic as well. So I've listened to the contribution of both of the panelists, and it's a very interesting topic. But I wanted to weigh in on this topic and just, take us back a few steps back. We are talking of personal data. We are talking of, in the context of this matrimonial proceeding that has inspired this session. So we talk of personal data, and then we talk of sensitive personal data. If you look at the Tanzania Personal Data Protection Act, it does have the provision that marital status is personal data. But what is missing is matrimonial status, and therefore anything related to a person's marital status is not treated as sensitive personal data. And what is the difference between personal data and sensitive personal data? So the difference between the two is how you treat the data based on the category under which it has been placed. The moment you say this data is sensitive, it means your security measures around that data is higher. It also means that the impact to the individuals that are considered to be, the impact of the individuals behind the sensitive data is potentially much higher. That means the damage they will suffer could potentially not be reversible. When we look at this Salome case, you can already see the level of impact the ex-husband is going to face in the society, what it means. He's ruined for the rest of his life because this fact about his health situation has been exposed to the public, and there's nothing he can do about that. So my concern, or I guess our concern for us that are in this profession, and what we would like to see, is the consideration by lawmakers to consider marital statuses and therefore anything connected to that as sensitive data. And what that means is when you come across scenarios or cases like the one, the Salome case, it means that the way courts will handle the case would be different. First of all, we know there are court proceedings that are held in camera. That means they are private. We know how, for example, the best example I can think of right now, since I didn't prepare, is any case that involves children. You never get to learn the names of the children. You never get to see those children testifying in court. Their testimonies are always collected privately. You hear the facts of the case, but you'll never be able to figure out who the children were. Therefore, even though the public gets to know about the facts of the case, law students and, lawyers, judges, and the wider community get to use these case laws for their research, for their studies, without having to know who the parties were, and therefore their reputation don't get, damaged. And that is what it means when you say, or when you categorize a certain data elements as sensitive personal data. What you're simply saying is we are going to take extra care of this information. And that's that's the difference between, personal data is in general personal data and sensitive personal data. And if that was the case in this, in Salome's case, then we would still learn that there was this situation. these are the facts of the case, but we would never know who the people were. Like you mentioned in the beginning, and the parties, the panelists mentioned this, is that it is good to use abbreviations. When you use abbreviations, it can be anybody. And that is one way to mitigate this disconnect between the judicial proceedings, because again, the Data Protection Act is a new act, right? It just came into force. So obviously it's going to butt head with existing processes, with existing procedures, with existing laws. So you're kind of trying to find a harmonization. You're trying to find a balance between the incoming law, versus the existing laws and the existing procedures. Because another point that I wanted to make is, on a general perspective, the reason why things are changing now is because we live in the digital age. And because of that, information is traveling far and wide, and it has much worse impact and implication than it was 20 years ago. 20 years ago, 25 years ago, the internet was not as big as it was. So the damage that someone would suffer, because we could argue that, okay, marital proceedings have always been like that. And that is a fact. They've always been public. The information has always been public. So why should this new law want to change the status quo? The reason the new law wants to change is because we now have digital personalities. And those digital personalities have shown to have far more damaging outcomes than what it was back in the dark ages. So that's what I wanted to contribute to this discussion. Thank you.
Josefina, thank you so much. What a lovely contribution. Very down to earth, very realistic. Thank you so much for all of those different points. We truly value your contribution. And it really does make us think a lot about how to protect the personal information of parties involved in courts, especially being sensitive to members of society like children, people who are in matrimonial matters. It can be a very sensitive time. So thank you very much for that contribution. I really appreciate it. I'm just trying to check and see if there are any other questions from our audience members. Any questions to the panelists? Please, you're very welcome. You can either raise your hand or type in the chat. I am just quickly checking to make sure I'm not leaving any question out. Does anybody have any questions or any comments? It could be a comment as well. Anything that you may have seen in your work, in your private dealings. Yes?
One of the questions that were directed to me, I think I haven't answered them. And one of them was what changes could be made in our act, the Personal Data Protection Act, to better protect personal information in matrimonial proceedings. So my opinion is that instead of dealing with the Personal Data Protection Act, specific laws should be amended to reflect or align with the Personal Data Protection Act. Such steps could be, for instance, having provisions that allow parties to matrimonial proceedings bring up applications. They could be suomotu, they could be ex parte applications by parties to matrimonial proceedings to have their case not published. And such other, if such proceedings have facts that disclose very sensitive personal data. Another option could be the court on suomotu giving an order to that effect. So courts could come up with a suomotu motion, making an order to the effect that since the judge is saying, since after going through the facts of this case, I hereby order that the proceedings shall be heard in camera, or there will be no publication, etc., etc. The previous speaker spoke of the proceedings that are related to children. Our Rule 11, for instance, of the Law of the Child Juvenile Court Proceedings procedure rules has provisions to that effect, that proceedings where the children are part 2 cannot be published, cannot be accessed. They're always carried out in camera, etc., etc. So my point is that our procedural laws, be it criminal or civil procedure act, they could come up with provisions to that effect of ensuring that whenever a case has sensitive information, then the judge could make any order to that effect.
And
But
Mr.
before I leave, we also have Section 188 of the Criminal Procedure Act. It has provisions to the effect that the DPP could bring an application, an ex parte application, to not publish the names of the witnesses and their whereabouts if the security concerns of the said witnesses would be put into jeopardy. So at least you see, even before the the enactment of the Personal Data Protection Act, our laws had such provisions to protect privacy and security of witnesses and parties to the cases. So maybe we'll be having somewhere to benchmark, because some of the such provisions are already in some legislations.
And Mr. Mutalemwa, I think that is very important, because given that that provision is already there, then it is a matter of educating and making sure that the parties also know about their rights and that they can choose to, given the nature of the case and in the circumstances, choose and to say not to have their sensitive information published or put in this and that place. I think educating the parties as well is very important. To the lawyers or those specific parties, it is their duty to inform the parties as well. So that was a very important contribution, and I thank you so much for that. I see there's a question in the chat room, and I'd like this question to be answered by both Ms. Vanessa and Mr. Mutalemwa, given the 2 data protection commissions that we have in both countries. So the question says, will the commission give directives to the judiciary to increase the security around proceedings, such as matrimonial cases? Vanessa, for example, in Nigeria, with the Data Protection Commission of Nigeria, do we see, or are there any steps in giving directives to courts, to the judiciary, on increasing this security?
That's a very interesting question, because I think right now the commission here is kind of targeting some kind of institutions that deal with at least biometric personal data right now. So our National Identity Management Commission right now, they experienced a leak, and this is obviously your national identity numbers being leaked online, right? So this is their primary focus right now in terms of any government agency that they're looking into. But definitely, I think once more people put enough pressure on them to look into, right after this NIMC debacle, I'm guessing, we could definitely start putting pressure on them to look into other government ministries and agencies and departments, because they do our data protection laws. There's a specific one to guide public institutions. right? And then honestly, they tried initially not to focus so much on public institutions, but we've realized that most of our leaks, most of our most stressful data breaches tend to happen not just from private entities, but public ones as well, who hold the data of the entire nation, right? Which means that the focus ordinarily should be shifted greatly. At least half of their focus should be on the public institutions right now. So as a result of this NIMC 1, I can definitely say that it seems like in the coming years, coming months even, a lot of focus will go onto the public institutions. They've started giving trainings for their DPUs and IT professionals. They've made it mandatory for them to also register with the commission. So, I mean, let's just hope that the NIMC debacle is sorted out as soon as possible. But it seems right after that, this seems like the next best step to look into the judiciary for sure.
Thank you, Ms. Vanessa. We hope that when that does happen, you will share updates with us so that we do get to follow up on what's happening in Nigeria as well. Thank you so much. Yes, Mr. Mutalemwa, do we see this happening for Tanzania?
So my take is that if we have laws in place, then you don't need the commission to come up with the directives. If you have the laws in place, the laws that align themselves with the Constitution and the Personal Data Protection Commission. As you are aware, our Article 16 of the Constitution of the United Republic of Tanzania sets out the basic private rights of individuals. And it goes out to say authorities shall come up with legislation to give the privacy its effect. So you have Section 16, Article 16 rather, of the Constitution in place. Then you have the Personal Data Protection Commission, which under Section 4 of the Act, it goes by saying the objectives of this act is to protect the privacy of individuals and I lost my point, but it goes out saying the protection of privacy of individuals and collection and processing of personal data to be guided by the principles of this act. So courts should align themselves. If the laws were in place, then you would not need directives from the commission, but courts would align themselves with the specific provisions of the law. Again, if you see the principles set out in our Data Protection Act, it directs that data should be adequate and should be limited to what is necessary for the purposes of its collection. And the process should be in accordance with our act, and so to speak, our Article 16. So my take, as much as I can speak, is that if we have the laws that reflect Article 16 of the Constitution and the Personal Data Protection Act, then you would not need any directives from the Commission.
All right, thank you, Mr. Mutalemwa. And in that spirit, I am also mindful of the fact that the Personal Data Protection Commission of Tanzania, being an independent body, is also at a place where they can offer these reminders, I would say, and education to the public in as much as the laws are also there. I'm happy to see that the Personal Data Protection Commission can always offer these reminders and these public notices on what courts need to do with regards to the protection of people's sensitive information, and perhaps even reminding these different actors of what the laws say whether it's the Law of the Child's Act, whether it's the Arbitration Act, and all these other different components. So thank you so much for that contribution. Thank you very much. I'm trying to see if there are any questions from the audience before I bring the last few closing discussion points. Okay, now the last final question to both you and Ms. Vanessa. What would you say are the roles that public awareness plays in protecting the privacy in judicial proceedings? So we've spoken a lot about what the commission needs to do, what the legal frameworks need to do, you know, what judges, what lawyers need to do. But in terms of coming down to society, coming down to the community, what role does that public awareness play in protecting the privacy in judicial proceedings, whether you are a party yourself in that matter in court, whether you are the lawyer representing the person, a family member, an advisor? How do we see public awareness playing or shaping in the protection of these judicial proceedings? Mr. Mutalemwa, I see you thinking a lot. Do you have a contribution to this you'd like to share? Welcome.
Thank you so much. If the parties to the proceedings have awareness to the personal data, and in this case, sensitive personal data, then you hope or you expect that parties would give instructions to their attorneys, if at all they have engaged the attorneys, instruct their attorneys to that effect, that see to it that my sensitive personal data is not exposed. If they don't engage attorneys, then parties themselves could see to it that their personal data is not exposed, either by making applications to courts to that effect, or opting to go for ADR, as some colleagues suggested, and court officers, again, if court officers are aware of aware and sensitive of personal data, they will make sure that they align themselves with the laws and legislations to the effect that personal data is protected. So it extends to parties to proceedings, the lawyers, the court officers, and the public at large. The media, again, the media should be involved again.
Yes, sir. What role do you see the media playing specifically?
They say information is power, and the media is the major player in this role of bringing about awareness. So the media, you can do without it. You can't do without the media, because information is power. The media will assist in bringing about awareness to the public at large. So I don't see any success without engaging the media.
Very true, very true. Information is power. Thank you so much, Mr. Mutalemwa. And over to you, Vanessa. What role do we see different stakeholders playing in public awareness in this matter?
Okay, so sorry. So with the other actors, except from the commission in Nigeria, I'd say public awareness has definitely gone up at least by 30% since 2019 with the NDPR, right? Initially, when our first regulation came out, they were having like talk show hosts with some data protection knowledge come on and talk to the people, which which is a way that Mr. Mutalemwa's idea of the media coming in was a very good idea, because this was a very simple way to disseminate information around the country without it being like a lecture, if you understand what I'm saying. Because it's in this passive kind of conversations that just let people just kind of register it slowly, a bit slowly, but register it that like, okay, I have a right, or I have a couple of rights when it comes to my data, right? And by registering it over time, eventually these kind of issues of like proceedings and marital proceedings and similar matters, eventually they come up. And then especially when you realize like, this data that what I'm about to share, because reading the Salome case, the respondent, he barely ever came to court, right? Probably out of the shame or embarrassment of having to deal with it publicly, whatever it was, but the case was decided without him actually coming into court. Radio stations, I don't think it has to be we're not as developed as some other continents in terms of people just picking up their rights immediately, especially when you realize that the disparity between the literate and illiterate populations can be quite wide, especially somewhere in Nigeria. Unfortunately, the disparity is very wide. So the amount of people that even understand English enough to understand what you're talking about with data protection, right? You could have to not dumb it down, but find a way to communicate these kind of rights, which the law can't do alone, which the commission can't do alone. So they're going to just keep on having to engage or promote people that want to talk about these things via any means, right? And I think slowly but surely, eventually, more and more of these things will start coming to light. With like loan sharks, it's only of recent as well that lots of people start realizing like this thing where loan sharks do, where if you default in paying, they send out these messages to like anyone on your contact list because they've gotten access to your contact list, and they're sending out horrible messages with your pictures, and they're saying this person is a terrible person, he's owing us a crazy amount of money, which is probably not true. You're probably owing them like $5, and then they're saying you're owing them 100 million or something stupid, right? So I think sometimes the lesson is learned when in such situations, which shouldn't be, right? It's only in some of these situations that I realize like people picked it up fast and they're like, they shouldn't be allowed to do this, right? But there's softer ways to engage people and make sure that they understand their rights, which I think the media thing comes into play. Data privacy enthusiasts, not just lawyers or whatever, anyone that understands this concept should honestly talk to other people about it. Any opportunity you have or you can, you just mention, because it's so basic. Your rights are so fundamental and so basic that honestly it should come up in more and more conversations, because it's not even hard. Like the laws don't make it hard to actually enforce your like rights with like data subject access requests or like deletion, unsubscribing, all these things. These are not actually really hard rights to enforce. So that's what I would say, that like, more and more people should just, the way everyone here is on this call right now, just take it from here today. See if you can have a conversation with one person per day or something, or one person per month about this thing. And then surely but slowly, it will disseminate enough information about data protection.
Ms. Vanessa, I think you have just wrapped up this webinar so well with that. Anyone who knows about this information should tell the next person about this information. Right. I thank you so much. And we have actually come to the end of our session today. To all of you lovely guests for being here with us, to Mr. Mutalemwa and to Ms. Vanessa. Thank you to everybody for being here with us. There's a very beautiful comment from Josephina in the chat saying that for African countries, mobile communication has become very powerful and can be a powerful tool to raise awareness. In those WhatsApp groups, in those Telegram groups, do tell a person to tell a person that be very careful with judicial proceedings. Know that you can request for your information to be private, for your name to be private, so that we help each other out in this. Thank you all very, very much. This webinar has been recorded. Should anybody want to listen again, should anybody want to come back to this information, and the links have been shared in the chat room, but you're also very welcome to follow Tanzania Privacy Professionals Association on our social media pages, as they had been placed in the chat room. We hope to have you again, Ms. Vanessa, and please give our greetings to Nigeria, to many people there, to your office, and also Mr. Mutalemwa, thank you very much. Pass our greetings to the Office of the Personal Data Protection Commission, and we hope to have you all again and again. Ms. Vanessa, someone is asking for your LinkedIn profile. Yes. Yes, your LinkedIn profile. And Shali, we will share the link with you. And
yeah,
also,
Josephina said she has one comment before we wrap up as well.
Yes, I do have.
Okay,
Sorry,
welcome.
I can be very talkative. But Justin, you can stop recording. So this doesn't have to be recorded. This is